Mr. Nukanto thought that the applicant has made out a case for urgency. For that reason, the matter struck off the roll with costs. I note that Mr. Nukantobi had asked for costs of 3 counsel. I'm of the view that the matter does not justify 3 counsel in this matter. Therefore, the matter is struck off with costs in the normal course.
As your ladyship pleases.
As the court pleases, my lady.
Thank you. The court will then adjourn. So the application was drafted between the 21st and the 22nd of December 2021, with service affected on the respondents on the 22nd of December 2021. The respondents served and filed a notice to oppose on the 23rd of December 2021. According to the applicant, the matter is urgent in that the publication of the allegations regarding the applicant has continued and is continuing to cause harm. The only reference made with regard to harm or the threat of harm is the incident at Southgate Mall and persons passing her home and making statements towards her or showing her the finger. According to the applicant, the first respondent in particular is determined to continue her online attack on the applicant and is refusing to engage on the issue. Now, Ms. Olivier argued that the matter is urgent and she referred in the applicant's papers to articles referring to elderly persons who are alleged to be witches being attacked by
what would happen if nothing is done. What she's asking your ladyship and the court specifically to do is to consider the harm she's currently suffering and assist her by, in the interim, removing all allegations pertaining to her in terms of this one video and the one post made by the respondents. It's not an attempt to silence, but an attempt to preserve her dignity, her good name, and her safety. It's not enough for the respondents to say that, well, I didn't mean it like that, and therefore should be interpreted like that. Because the courts in South Africa have not developed allegations and defamation pertaining to post on social media, I have referred your ladyship to 2 cases which was decided in the Supreme Court in the UK. The first being Monroe versus Hopkins and the other being Stoker and Stoker. I've uploaded both of them, both for your ladyships and my learned friends' convenience. And the courts have considered the effect an applicant has if a speedy approach is not taken in matters where a defamatory statement has been publicized. Now, because it has already been publicized, the argument could be, well, the horse has bolted and therefore it should be allowed to continue. Well, my lady, it does not explain why there should be an ongoing harm only because it has already been posted. The respondents did not approach the applicant and said, we want to post the following statements about you in social media, online, on Instagram. What would you like us to do? So she had no opportunity to approach the court prior to the postings. It now has been posted. It has a very real effect on her life. It continues to have a very real effect on her life. And if the matter is not heard on an urgent basis, it provides a platform where one party's interest apparently trumps the other party's, where the respondents can continue with their social media and media onslaught of the applicant without it even being the truth, my lady.
what has been suggested that it, then thirdly, what has been suggested that it's only about removing this name and then keeping others, it's actually false. The reality of the application is that it's the entire thing that must be taken down. And the question is, who benefits from that? It is the applicant's son who benefits from it. So that's point one on Muti and why we say the Holomisa judgment.
Mr. Newton, Toby, because we lost part of your argument. So your first point was the issue around continued harm is addressed by McCarthy versus the UDM.
Versus insofar as reputational harm is concerned. In other words, the harm to dignity, it's answered fully. And then the personal harm, which is I'm about to be attacked because you've called me a witch. Has no factual foundation because witchcraft is a self-description. And it has no foundation on what the first respondent actually said. And in any event, on a proper analysis of what the first respondent said, she says, the reason I say she uses muti is because I saw her using muti. In the answer, in the replying affidavit, that allegation is just never addressed. It is the most astonishing thing. It's just not addressed whatsoever. So she doesn't say yes or no, or you were mistaken, etc. That allegation is in the answering affidavit, not addressed in the reply, it stands. And then thirdly,
you'll have an opportunity to reply, Ms. Willoughby. Don't shake your head. I'll give you an opportunity to reply.
My apologies, ma'am.
yes. And then thirdly, it is also absurd because of the references to Ms. Kelly Kumalo that I have made, which appear at paragraph 18.1 of our heads of argument. So that answers the point one. And that is why the case does not meet Rule 612 of the Uniform Rules of Court. Drawn between what the first one, distinction must be drawn between what the first respondent actually said and what the applicant says she said. The first respondent has never called the applicant a witch. And the entire basis for urgency is that she has been called a witch. But that is a self-description, not a description from Mr. Pont. It is Ms. Mbambane herself who describes herself as a witch. So if it is defamatory, it's self-defamatory. What the first respondent actually said was that she, the applicant, uses muti. Now, the respondent, and it's crucial to note this point, my lady, in the answering affidavit, the respondent explains the factual basis for the allegation that the applicant uses muti. The factual basis is that she personally witnessed.
Can you please mute? Thank you.
So the factual basis for the allegation that the applicant uses muti is explained in the answering affidavit. There are two. One is the applicant, the first respondent says, I witnessed her and her son, Mr. Mahuranya, using muti. So I saw her using muti. Secondly, she says, in any event, the applicant
on 006-6.
Are you referring to the respondent's heads of argument or the founding affidavit?
The answering affidavit, my lady, by the first respondent. So it's 006-6.
Hold on. Yes.
So what the respondents, and specifically in this case, the first respondent says to the court, is not that the matter shouldn't be heard at all or should have been placed on the urgent roll. It says, why couldn't it have been placed on the 4th of January's urgent court roll? Now, whether it is placed on today's urgent court roll, The urgency remains urgent, my lady. Sorry, my lady.
At what paragraph do you see that?
It's right at the top. So it starts at 006-5 at 36.6, and it then continues into that paragraph.
Okay.
So by admitting that it should have been set on next week's urgent roll, my lady, is an admission that the matter is urgent. To state in their heads now that there is no urgency when the case made out by the first respondent is that there is urgency, but we just don't want it to be heard today, is not what was pleaded. Now, I've set out in my heads of argument, my lady, that what your ladyship should consider when it comes to urgency is not just the fact that whether or not there has been compliance with the practice directive. The protection of a party when there is no other remedy should be at the forefront of what the court should consider. And what the applicant says to your ladyship is that she has now attempted every other remedy in the shortest possible time in order to avoid coming to court. She has approached the first and second respondent. They have been advised specifically not to engage with her. She has approached the South African police. They have not taken the matter further.